A good day to everyone. Welcome to our teleconference focusing on the guidelines and laws regarding nursing informatics. Thank you, student nurses of St. Mary's University, for joining us today. Your participation in today's discussion is invaluable as we delve into this vital aspect of nursing practice. Without further ado, let me introduce our distinguished speakers from all around the world who will be sharing their knowledge with us today. Please join me in welcoming Mr. Chaitak Kim, Miss Janine Smith, and Mr. Mohammed Alakabir. On behalf of St. Mary's
Thank you,
University,
thank you.
it is a great pleasure that we extend to you a warm welcome. As we start, I encourage all of you to actively participate in our discussion. Feel free to ask questions, share your insights, and engage with your fellow student nurses. Now, I will hand over the floor to our first speaker, Mr. Chae-Tek Kim, who will discuss intellectual property law.
Hello, thank you, Ma'am Claisel, and good day, Marian students. I am Chester Smith. So first thing first, let's define intellectual property, okay? When we say intellectual property, this pertains to intangible assets resulting from the creation of the mind, such as it can be invention, literary, and artistic works, and it can also symbols, names, images, and designs used in commerce. The legal rights which result from the intellectual activities in the industrial, scientific, literary, and artistic fields. So why do we need to know what is intellectual property? And what is the purpose of this? And what is the legal basis of this? Okay, actually, the legal basis of this is the constitutional basis itself. Article 14, Section 13, 1987 Constitution of the Philippines. Okay, this article, the state shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such period as may provided by law. This idea of this is to encourage the inventors and artists and scientists, to produce more or creative artistic works or invention in order to benefit the people. So when in exchange the benefit from the people by those invention, in exchange for the entertainment that is being given to us. As literary and artistic works, the state gives some sort of protection. Okay? In a nutshell, parang gano'n lang siya. Yun yung pinaka-purpose ng Intellectual Property Code. Then, nag-i-invent ka or nag-trademark ka or meron kang creation of the mind, meron kang design since nagbe-benefit ang public from that. Proprotektahan ka namin but you could continue sharing whatever you invented or whatever you designed in exchange for protection. That's for the constitutional basis. Okay, under the intellectual property, there's a copyright, trademark, and patent. So, let's go in the copyright. So, copyrights, this is the pagbibigay ng exclusively legal rights sa creation or kung paano gamitin or kung saan mo gagamitin ito. Under the copyright, I'll give an example. Sino yung nanonood dito ng NBA? Lahat ng nakikita mo, napapanood mo sa NBA, pagmamay-ari ng NBA. Then, kung papanoorin mo to, papakinggan mo, then it's okay. It's generally okay. But if you download it and post it in your social media, dyan na tayo makakaproblema. Okay? Kung that's the under of the copyright. So if you credits the owner, properly credits, and that's okay. But if kung sasabihin mo lang na CTTO lang, but that's enough. That's enough to credits the owner. But if nilagay mo lahat and complete to cite that that article, that's okay. So that's the under of the copyright. Then let's go to the trademark. Trademark is the product that's authentic and it's either genuine product that the product meets a certain standard of quality that they advertising the articles they symbolize. It meaning to say ito yung pagkakakilanlan sa kanila tulad ng Jollibee, McDo, ganun. Hindi mo naman pwedeng magprito ka lang ng manok, tatawagin mo ng Jollibee, 'di ba? Then yung gamit mong iPhone na yan, yung may kagat na mansanas na dyan, is pagmamay-ari ng Apple, produkto nila yan, at hindi yan clone. At yung mga gamit mong brand na pen shop, bench, that is called trademark. Kung may nakikita kayo sa mga gamit nyo na TM, sabi niya sa baba, that's the trademark. Yan yung pagkakakilanlan sa produkto nila. That is the trademark. And let's go for the patent. For patent naman is protection for the inventors. Magre-register ka muna dito to know the products and para makilala yung products mo, magre-register ka muna para may protection yung invento mo na yun at para hindi makuha ng iba. That's the under of the patent. You should register muna para maprotektahan yung invento mo or yung mga creation mo. And that's all for the intellectual property law.
Thank you, Mr. Kim. Now let us welcome Miss Smith.
So, good afternoon, everyone. In this second segment, we're diving into the intriguing world of copyright law in nursing informatics. So, this is a vital aspect of your profession since you guys will be nurses in the future. But before we dive deep into our discussion, let me ask, who here is familiar with copyright law? Anyone? So, Mr. De La Cruz,
So copyright law is about using and sharing information responsibly within legal boundaries and respecting the rights of creators by crediting them for their works.
that is right, Mr. De La Cruz. Understanding and adhering to copyright law in nursing informatics is essential because it ensures fair treatment of original works, upholds ethical standards in information dissemination, and fosters a culture of respect and integrity within our profession. So, you guys must know this, starting from the basics of copyright law to avoid infringing upon copyright protections. So, as you can see on the first slide, it states that nursing professionals engaging in informatics must be aware of copyright basics, including the concept of fair use and the Technology and Copyright Harmonization Act. So this act provides guidelines for using copyrighted materials in online education, emphasizing the importance of respecting copyright protection when using others' works in educational settings. By adhering to copyright law principles and seeking legal advice when needed, nursing professionals can navigate copyright issues effectively in the context of nursing informatics. So, why does this matter? Or why must we grasp the basics of copyright law in nursing informatics? Hmm? So, because as future nurses, you will be handling sensitive patient information and respecting copyright laws ensures ethical use of these resources. Laws like HIPAA or Health Insurance Portability and Accountability Act of 1996 establishes federal guidelines for electronic standards and patient identification, safeguarding health information, as well as the 21st Century Cures Act of 2016, which aims to modernize healthcare and encourage innovation while maintaining patient privacy. So, as you can see on the third slide, basically, it's not just about legal compliance. It's about ethical practice and ensuring quality education in nursing informatics. So, let's equip ourselves with the knowledge of copyright law basics and its relevant regulations and let's embrace this journey together. So that ends my report. And if you guys have any questions, feel free to raise them up now. So, anyone? So, Miss Rosel, can you state your question?
Ma'am, how can copyright law be utilized in nursing informatics?
Hmm. So, just what I have said a while back in my presentation, I emphasize the significance of copyright law in nursing informatics. Copyright law serves to prevent copyright infringement by safeguarding the works of original creators, including educational materials, software, and research publications. It ensures that rightful owners are credited, and in doing this, we promote ethical and legal use of copyrighted materials within the field of nursing informatics. So, Mom, did I answer your question?
Yes, ma'am. Thank you, ma'am.
Yes. Okay, thank you po. So that ends my report.
Thank you, Ms. Smith. Now, let us welcome Mr. Muhammad Alakavir, who will provide insights into the privacy of personal and public domain.
So, good afternoon, everyone. I am Mohammed Alakavir, and today I will discuss the privacy of personal and public domain. So, we first differentiate the difference between private and public domain. The private domain is that it belongs to a particular person or organization that may allow others to see or use it with the permission of the client or if they pay for it. While personal data is given by the client and used in the private domain, the information will remain private between the institution or hospital and the client or patient. Now that we've differentiated the personal and private domain, we will discuss and apply this in the field of nursing informatics. So first, I will discuss that there are four provisions of the Code of Ethics for nurses that merges professional nursing career with technology and nursing informatics. The first provision is the promotion of patient rights in the digital realm. The second provision is the advocacy for patient-centered technology. This means that patient will more be able to access their records in healthcare. And the third provision is the protection of patient health and safety through technology. Lastly, the fourth provision is the insurance or the ensuring of safety and security of health information. With this, health information technology or HIT systems are developed and created with the help of nurses, and they make interdisciplinary collaboration possible. This also prevents unauthorized access or disclosure of sensitive data. So may I ask someone to give one example of this application of ethical provisions in the scope of nursing informatics. So Miss Joanna.
Yes, sir. An example is what we call EHR, which also stands for Electronic Health Record.
Okay, that is correct. So now, is anyone here familiar with the EHR? May I call someone to explain what EHR is? Oh, so Joanna again,
Yes, sir.
please.
So EHR is like electronic version of the charts that we have for our clients. So it's within it are the medications, the allergies, the laboratory results, and so forth.
So yes, thank you very much for that wonderful answer. The EHR, as Miss Joanna just said, these are made possible because of these four provisions. And the next that accompanies these provisions are laws that helps implement these provisions. So in the laws, there are two main laws that implements these provisions. The first being the Health Insurance Portability and Accountability Act of 1996, also known as the HIPAA Act. The HIPAA Act privacy rule sets national standards for the protection of individuals' medical records and other personal health information, also known as PHI, held or transmitted by covered entities, including healthcare providers, health plans, and healthcare providers. These health plans and healthcare clearing houses, it establishes patients' rights to access their health information, control its disclosure, and protects its confidentiality and security. This rule protects most individually identifiable health information held or transmitted by a covered entity or CE in acronym or its business associate or BA in any form of media, whether this is electronic or written in paper or it's oral or just talked about. The privacy rule calls this information protected health information or PHI. Individually identifiable health information is information including demographic information that relates to the individual's past, present, or future physical or mental condition. The provision also of healthcare to the individual or the past, present, or future payment for the provision of healthcare to the individual. The next law that I will discuss is the Republic Act number 10,173 or 10173. This is also known as the Data Privacy Act of 2012. To summarize this act, this governs the protection of electronic health records or EHR and patient data privacy. While the Data Privacy Act is not specific to healthcare, it provides a comprehensive framework for the protection of personal information, including health data in various sectors and including healthcare entities handling patient health data, including hospitals and healthcare providers, are required to implement appropriate security measures to protect the confidentiality, integrity, and availability of the data. This includes safeguarding or protecting against unauthorized access or disclosure of the nurses to others, and inalteration of the documents and destruction of EHR. So that concludes my discussion about the privacy of personal and public domain. Thank you, everyone.